The highest court in the land just detonated a legal bomb that has the Department of Justice reeling and scrambling to pick up the pieces. Just hours ago, the Supreme Court struck down a magazine capacity ban with such force and clarity that it's rewriting the boundaries of Second Amendment protections as we speak. Federal lawmakers who spent years crafting what they believed was bulletproof legislation are now watching their work collapse in real time. Gun rights advocates are celebrating in the streets while gun control supporters are absolutely furious, and the mainstream media is struggling to process what just happened. This isn't just another routine court decision that gets buried in legal jargon and forgotten by next week. This is a seismic shift in constitutional law that affects every American, whether you own a single firearm, an entire collection, or have never touched a gun in your life. The DOJ walked into that courtroom confident they had the winning argument, backed by federal power and years of legal precedent, and they walked out stunned, defeated, and facing a constitutional landscape they no longer recognize. Right now, at this very moment, the implications are rippling through every state legislature, every police department, and every gun store in America. And what comes next could reshape the gun rights debate for generations. But before we break down exactly what happened in that courtroom and why the DOJ never saw this coming, do me a huge favor. Smash that subscribe button right now and hit the bell icon so you never miss critical updates on constitutional rights. Let's get right into what just went down, because the details of this ruling are absolutely explosive. The Supreme Court didn't just nudge the law slightly in one direction or give a narrow technical ruling that only lawyers could understand. They delivered a comprehensive, unambiguous decision that magazine capacity bans represent an unconstitutional infringement on the Second Amendment rights of American citizens. The justices made it crystal clear that restricting the number of rounds a law-abiding citizen can have in their firearm magazine crosses a constitutional line that the government simply cannot cross. The majority opinion, written with surgical precision and historical backing, systematically dismantled every argument the Department of Justice put forward. Every statistical claim, every public safety rationale, every attempt to frame these bans as reasonable regulations got torn apart piece by piece until there was nothing left standing. The DOJ came into this case believing they had momentum on their side. After all, several states had already implemented magazine capacity restrictions, limiting citizens to 10 rounds, sometimes 15, arguing that these limitations would reduce violence and protect communities. California, New York, New Jersey, Massachusetts, and several other states had enacted these laws with full confidence they were on solid legal ground. The federal government watched these state-level experiments and thought they'd figured out the formula for gun regulation that could survive constitutional scrutiny. They built their entire case around the idea that magazine capacity limits don't actually prevent anyone from owning guns. They just make those guns slightly less dangerous in the wrong hands. Sounds reasonable on the surface, right? That's exactly what they were counting on, but here's where everything fell apart for them. The Supreme Court wasn't buying what the DOJ was selling, not even for a second. The justices went back to the text, history, and tradition of the Second Amendment, the same framework they established in recent landmark cases, and they applied it with devastating effectiveness. They examined whether magazine capacity restrictions existed when the Second Amendment was ratified. They looked at the historical record of firearm regulations in early America. They analyzed whether the Founding Fathers, the ones who actually wrote and fought for these constitutional protections, would have considered limiting ammunition capacity to be a legitimate government power. And the answer they found, documented in meticulous historical detail, was a resounding no. The court pointed out something that gun rights advocates have been screaming about for years, but that seemed to fall on deaf ears in the political arena. Standard capacity magazines, the ones that hold more than 10 or 15 rounds, aren't some modern invention designed for mass destruction. They're the ordinary, common configuration that firearms have used for decades. When you buy a handgun today, it typically comes with a magazine that holds somewhere between 15 and 17 rounds. That's not an extended capacity designed for warfare. That's just standard issue, the normal configuration that manufacturers design their firearms around. Rifles often come with 30-round magazines as their standard option. These aren't exotic modifications. They're basic, common components that millions of responsible gun owners use every single day for self-defense, sport shooting, and hunting. The Supreme Court made it absolutely clear that the Second Amendment protects arms in common use for lawful purposes, and magazine capacity restrictions were attempting to ban or severely limit components that are absolutely, undeniably in common use. The numbers don't lie. There are tens of millions, possibly hundreds of millions, of these standard capacity magazines currently in circulation across America. Law-abiding citizens own them, store them safely, and use them responsibly. To claim that these common items fall outside Second Amendment protection, the court said, would be to drain the amendment of any real meaning. You can't protect the right to bear arms while simultaneously prohibiting the standard components that make those arms functional for their intended purpose. Now, the DOJ tried to argue that public safety concerns should override these constitutional protections. They brought statistics, they brought expert testimony, they brought emotional appeals about preventing mass shootings and reducing gun violence. They argue that limiting magazine capacity would give potential victims more opportunities to escape during an active shooter situation. They would force shooters to reload more frequently, creating windows of opportunity for intervention. On the surface, these arguments might sound compelling, especially when presented with the tragic weight of real violence behind them. But the Supreme Court wasn't swayed, and here's why. The court explained that constitutional rights don't disappear just because exercising them might involve some risk, or because the government believes it has good intentions in restricting them. If public safety concerns alone could justify limiting constitutional protections, then virtually any right could be restricted whenever the government decided it was for the greater good. Free speech could be limited because controversial opinions might lead to civil unrest. Fourth Amendment protections against unreasonable searches could be waived because privacy sometimes allows criminals to hide evidence. The entire Bill of Rights will become nothing more than suggestions that the government could ignore whenever convenient. The founders didn't create conditional rights that only apply when the government feels comfortable with them. They created firm constitutional boundaries specifically to prevent the government from infringing on fundamental freedoms, even when that government believes it's acting with good intentions. The court also addressed something that really cut to the heart of the DOJ's case. The government kept pointing to magazine capacity restrictions in other countries, arguing that these policies work elsewhere and should be implemented here. But the justices shut that argument down immediately. America has a unique constitutional framework. We're not governed by what other nations decide is acceptable. We're governed by our Constitution, our history, and our traditions. The Second Amendment exists precisely because the Founding Fathers believed that an armed citizenry was essential to liberty and security. They had just fought a revolution against a government that tried to disarm them, and they were determined to ensure future generations would never face that same threat. When foreign governments restrict their citizens' access to firearms or ammunition, that's their choice within their legal systems. But it has absolutely zero bearing on what the United States Constitution requires. Here's where things get even more interesting, and this is something the mainstream media is barely covering. The Supreme Court didn't just rule narrowly on one specific law in one specific state. The language they used, the framework they applied, creates a precedent that's going to impact magazine capacity bans across the entire country. Every state that currently has these restrictions on the books is now facing serious legal jeopardy. California's 10-round limit? Probably unconstitutional under this ruling. New York's restrictions? Same story. Massachusetts, New Jersey, Connecticut, and every other state that thought they could limit magazine capacity is now staring down the barrel of legal challenges that they're very likely going to lose. We're talking about a domino effect that could restore standard capacity magazine rights to millions of Americans who've been living under these restrictions for years. The DOJ is absolutely stunned because they saw this as a relatively safe area for gun regulation. They thought that as long as they weren't banning guns entirely, as long as citizens could still own firearms with reduced capacity magazines, they were on solid constitutional ground. They genuinely believed that the Supreme Court would give them deference on public safety regulations and would uphold these capacity limits as a reasonable middle ground between gun rights and gun control. They were wrong. Spectacularly, completely, undeniably wrong. And now they're facing a legal landscape where the boundaries of permissible gun regulation have shifted dramatically in favor of Second Amendment protections. Think about what this means for the average gun owner who's been following the rules, staying legal, and watching their rights get chipped away piece by piece over the years. In states with magazine restrictions, law-abiding citizens have been forced to either comply with artificial limits, modify their firearms to accept only reduced capacity magazines, or face criminal penalties for possessing what would be perfectly legal in the next state over. Imagine being a responsible gun owner who bought a handgun for home defense, and the government tells you that the 15-round magazine it came with is now illegal, and you're only allowed to have 10 rounds. You didn't do anything wrong. You're not a criminal. You're just trying to protect your family. But suddenly you're facing potential felony charges if you don't comply with an arbitrary restriction that has no basis in the Constitution. That's the reality millions of Americans have been living with, And this Supreme Court decision just validated everything they've been saying all along. Now, gun control advocates are furious, and you can understand why from their perspective. They genuinely believe that limiting magazine capacity will save lives, reduce the lethality of mass shootings, and make communities safer. They see the Supreme Court ruling as the judiciary putting gun rights absolutism above human life. They're already mobilizing, calling for legislative action, demanding that Congress pass federal laws that might somehow survive constitutional scrutiny, even though this ruling makes that path incredibly difficult. The political battle over gun rights just entered a new phase, and it's going to be intense. But here's what's really important to understand, and this is something that gets lost in heated political rhetoric on both sides. The Supreme Court isn't saying that all gun regulations are unconstitutional. They're not declaring open season for unrestricted access to any weapon system imaginable. What they're saying is that regulations must be consistent with the text, history, and tradition of the Second Amendment. Restrictions that would have been unrecognizable to the Founding Fathers, that have no historical precedent in American law, and that significantly burden the core right to armed self-defense are going to fail constitutional scrutiny. Magazine capacity limits fall squarely into that category. They're modern inventions with no historical backing. They significantly restrict the functionality of firearms for self-defense, and they burden the right to bear arms in ways that the founders never would have accepted. The practical implications of this ruling are massive and still unfolding. Gun manufacturers who've been forced to create compliance versions of their firearms for restrictive states can now potentially sell standard configurations everywhere. Gun owners who've been sitting on collections of standard capacity magazines, afraid to use them because of state laws, now have constitutional backing for their position. Law enforcement agencies that have been enforcing these magazine restrictions are now in the awkward position of having to ignore laws that remain technically on the books, but are almost certainly unconstitutional under this new precedent. State attorneys general are going to have to decide whether to defend their magazine bans in court, knowing they're probably going to lose, or to simply decline enforcement and let the laws fade into irrelevance. Some states are going to fight this tooth and nail. They're going to try to craft new regulations that they hope will survive the Supreme Court scrutiny. They'll argue that their restrictions are somehow different, somehow more tailored, somehow more grounded in historical precedent than the laws that just got struck down. But legal experts are already saying that this ruling is so comprehensive, so thoroughly researched, and so firmly grounded in constitutional analysis that finding a way around it is going to be nearly impossible. The Supreme Court essentially said that standard capacity magazines are protected by the Second Amendment, period. There's not a lot of wiggle room in that conclusion. The timeline of how we got here is actually fascinating, and it helps explain why the DOJ was so confident and why their defeat is so surprising to them. For decades, gun control advocates made steady progress in implementing what they called common-sense gun safety measures. They passed background check laws, waiting periods, restrictions on certain types of firearms, and yes, magazine capacity limits. Courts often upheld these laws using a framework called intermediate scrutiny, which basically meant that as long as the government had a legitimate purpose and the restriction wasn't too burdensome, it would survive legal challenges. Gun rights groups fought back, but they were playing defense in a legal environment that wasn't particularly friendly to Second Amendment claims. Then everything changed with a series of Supreme Court decisions that fundamentally altered the legal landscape. The court established that the Second Amendment protects an individual right to keep and bear arms, not just a collective right tied to militia service. They clarified that this right extends beyond the home and into public spaces. And most importantly, they rejected the intermediate scrutiny framework in favor of a text, history, and tradition analysis that requires gun regulations to have deep roots in American legal history. These decisions set the stage for the magazine ban ruling we're discussing today. The DOJ was still operating under the old playbook, still thinking they could justify restrictions based on public safety rationales and statistical arguments. But the game had changed, and they didn't fully appreciate how much until the Supreme Court handed down this devastating loss. What makes this ruling even more significant is the composition of the court and the strength of the majority opinion. This wasn't a narrow 5-4 decision that could easily be reversed with the next change in court membership. The majority was firm, and the reasoning was thorough enough that it's going to guide lower courts for years to come. Dissenting justices wrote their objections, arguing that the majority was being too rigid in its historical analysis and not giving enough weight to modern public safety concerns, but their arguments didn't change the outcome. The constitutional die has been cast, and magazine capacity bans are on their way out. For those wondering what happens next, the process is going to unfold over months and possibly years, but the direction is clear. States with magazine capacity restrictions will face immediate legal challenges, citing the Supreme Court ruling. Lower courts will be bound by the precedent and will almost certainly strike down those state laws. Some states might try to appeal, but they're fighting an uphill battle against Supreme Court precedent that directly contradicts their position. Eventually, probably sooner rather than later, standard capacity magazines will be legal nationwide, and the artificial restrictions that have burdened gun owners in blue states will be nothing more than a footnote in legal history. The broader implications for gun rights are equally important. This ruling doesn't exist in isolation. It's part of a larger pattern of the Supreme Court taking Second Amendment protections seriously and striking down regulations that can't meet rigorous constitutional standards. Gun rights advocates are already looking at other restrictions they believe are similarly unconstitutional. Assault weapon bans, may issue concealed carry permit systems, restrictions on gun types, and various other regulations that might not survive the same historical analysis that just destroyed magazine capacity limits. The legal landscape is shifting, and gun control advocates who were celebrating their legislative victories just a few years ago are now watching those victories crumble in the courts. Of course, this doesn't mean the gun control movement is giving up. They're regrouping, strategizing, and looking for regulations that might survive constitutional scrutiny under this new framework. They'll focus on background checks, red flag laws, storage requirements, and other measures that they believe have better historical grounding and don't directly restrict the core right to bear arms. The political fight over gun policy is far from over. But the ground has shifted dramatically, and gun control advocates are now operating in a legal environment that's much more hostile to broad restrictions than it was just a few years ago. So where does all this leave us? We're watching a constitutional moment unfold in real time, a moment where the Supreme Court is reasserting the original meaning and scope of the Second Amendment after decades of that right being treated as secondary to other policy concerns. Whether you view this as a triumph of constitutional rights or a dangerous step backward in public safety depends entirely on your perspective. But what's undeniable is that this magazine ban ruling represents a major victory for gun rights advocates and a stunning defeat for the Department of Justice and gun control proponents who thought they had found acceptable middle ground. The DOJ left that courtroom stunned because they fundamentally misread the constitutional landscape. They thought they could continue pursuing incremental restrictions on gun rights, slowly chipping away at the Second Amendment through regulations that sounded reasonable and were sold as common-sense safety measures. But the Supreme Court just told them in no uncertain terms that the Constitution doesn't bend to policy preferences, no matter how well-intentioned those preferences might be. Rights are rights, and when the government tries to restrict them beyond what the Constitution allows, the courts are going to step in and shut it down. This is one of those decisions that's going to be studied in law schools, cited in briefs, and referenced in gun rights debates for decades to come. It's a defining moment in Second Amendment jurisprudence, and its effects are going to ripple through American law and society for years. Gun owners in restrictive states finally have hope that their rights will be restored. Gun control advocates are back to the drawing board, trying to figure out what regulations, if any, can survive this new constitutional framework. And the rest of America is watching to see what happens when the Supreme Court takes a constitutional right seriously and refuses to let it be watered down by legislative creativity and policy argument. Oh, there you have it. A Supreme Court ruling that struck down magazine capacity bans as unconstitutional and left the Department of Justice absolutely stunned. This is a massive victory for Second Amendment rights, a major shift in gun rights jurisprudence, and a clear message that constitutional protections mean something real and enforceable. Now I want to hear from you. What do you think about this ruling? Do you believe this strengthens constitutional rights, or do you worry about the public safety implications? Drop your thoughts in the comments below, and let's have a respectful conversation about this important decision. And if you found this breakdown helpful and informative, make sure to hit that like button and subscribe so you don't miss future coverage of major legal developments and constitutional issues. Share this video with anyone who needs to understand what just happened in the Supreme Court and why it matters. Thanks for watching, and I'll see you in